Okay. Well, I'm on live, so.
Well, I'll be giving you the kiss on live viewing.
Okay. Love you.
Love you.
Get out of my frame.
Anna, sit behind your dad.
Huggy, kissy. Oh, I love your outfit. You're so cute.
Thanks.
Give me a hug and kiss. Watch out for those drinks.
Let me tell you what I
love
can
you.
do now.
Oh, that's almost Russian. Nice moves.
Alright.
You ladies have fun. I'll see you in a little bit, okay?
Okay.
I love you.
Mom, why are we
you.
walking backwards?
I love you so much.
There's so much.
Adios, amigos.
Adios, amigos.
Okay, nominations transmitted to the Senate. For immediate release, January 22nd, 2025, nominations sent to the Senate. Oh, here's the list of nominations sent to, oh, that's wonderful. Michael Boren of Idaho to be Undersecretary of Agriculture, Natural Resources and Environment. Vice Homer L. Wilkes resigned. Stephen Bradbury of Virginia to the Deputy Secretary of Transportation. Vice Polly Ellen Trottenberg resigned. William Briggs of Texas to be Deputy Administrator of the Small Business Administration. Vice Dilawar Suyed resigned. James Danley of Tennessee to be Deputy Secretary of Energy. Vice David Turk resigned. Richard Fortas of Missouri to be Undersecretary of Agriculture, the Farm Production and Conservation. Vice Robert Farrell Bonney resigned. David Futau of Virginia to be Deputy Administrator of the Environmental Protection Agency. Vice Janet Garvin McCabe. Doesn't say what happened there. Kenneth Keyes of Virginia to be an Assistant Secretary of the Treasury. Vice Lily Lawrence Batchelder. Mike, these are just the nominations. Some of those are interesting. You guys can kind of see these. I guess if you're on my live, you can't see these. Federal Housing Finance, Chief Counsel for Advocacy, Small Business Administration. Got somebody new in there. Department Secretary of Education, Penny Schwinn of Tennessee will be the Deputy Secretary of Education. The Vice Cynthia Minette Martin resigned. Let's see. Deputy Secretary of the Interior, Vice Tommy P. Boudreaux resigned. Catherine McGregor of Florida to be the Deputy Secretary of the Interior. Paul Lawrence of Virginia to be the Deputy Secretary of Veterans Affairs. Vice Tanya J. Bradsher resigned. So that's pretty neat. Those are the nominations sent to the Senate. Ending illegal discrimination and restoring merit-based opportunity. I'm definitely interested in this, so let's see what it says. By the authority vested in me as President of the Constitution of the Laws of the United States of America, it is hereby ordered. Section 1. Purpose. Long-standing federal civil rights laws protect individual Americans from discrimination based on race, color, sex, religion, or national origin. These civil rights protections serve as a bedrock supporting equality of opportunity for all Americans. As President, I have a solemn duty to ensure that these laws are enforced for the benefit of all Americans. Yet today, roughly 60 years after the passage of the Civil Rights Act of 1964, critical and influential institutions of American society, including the federal government, major corporations, financial institutions, the medical industry, large commercial airlines, law enforcement agencies, and institutions of higher education, have adopted and actively used dangerous, demeaning, and immoral race and sex-based preferences under the guise of so-called diversity, equity, and inclusion, or diversity, equity, inclusion, and accessibility, that can violate the civil rights laws of this nation. Illegal DEI and DEIA policies not only violate the text and spirit of our long-standing federal civil rights laws, they also undermine our national unity as they deny, discredit, and undermine the traditional American values of hard work, excellence, and individual achievement in favor of an unlawful, corrosive, and pernicious identity-based spoils system. Hardworking Americans who deserve a shot at the American dream should not be stigmatized, demeaned, or shut out of opportunities because of their race or sex. These illegal DEI and DEIA policies also threaten the safety to American men, women, and children across the nation by diminishing the importance of individual merit, aptitude, hard work, and determination when selecting people for jobs and services in key sectors of American society, including all levels of government and the medical, aviation, and law enforcement communities. Yet in case after tragic case, the American people have witnessed firsthand the disastrous consequences of illegal, pernicious discrimination that has prioritized how people were born instead of what they were capable of doing. The federal government is charged with enforcing our civil rights laws. I'm glad to read that. The purpose of this order is to ensure that it does so by ending illegal preferences and discrimination. Well, I guess that's good to end it. It would be nice to see if we could get some actual compensation for it. But let it be God's will. Section 2, Policy. It is the policy of the United States to protect the civil rights of all Americans and to promote individual initiative, excellence, and hard work. I therefore order all executive departments and agencies to terminate all discriminatory and illegal preferences, mandates, policies, programs, activities, guidance, regulations, enforcement actions, consent orders, and requirements. I further order all agencies to enforce our long-standing civil rights laws. Order all agencies, that would include EEOC and OSHA, and the Department of Justice. I further order all agencies to enforce our long-standing civil rights laws, which means they should now be able to be held liable if they don't, because the executive order says they have to. And to combat illegal private sector DEI preferences, mandates, policies, programs, and activities. Let's see, let's read that again because I think that we're including the private businesses and not just government agencies here. I further order all agencies to enforce our long-standing civil rights laws and to combat illegal private sector DEI preferences, mandates, policies, programs, and activities, which would include things like mandatory DEI training like I had at Comcast, which I'd like to add does receive government grants. And so I love that this actually addresses everybody, every American. That's the American way, and that's how it should be. Section 3, terminating illegal discrimination in the federal government. The following executive actions are hereby revoked. Executive Order 12898 on February 11th, 1994, federal actions to address environmental justice in minority populations and low-income populations. Executive Order 13583 of August 18th, 2011, establishing a coordinated government-wide initiative to promote diversity and inclusion in the federal workplace. A government-wide initiative. When was that? In 2011. To promote diversity and inclusion in the federal workplace. Executive Order 13672 of July 21st, 2014, further amends to Executive Order 11478, Equal Employment Opportunity in the Federal Government, and Executive Order 11246, Equal Employment Opportunity, and the Presidential Memorandum on October 5th, 2016, promoting diversity and inclusion in the national security workforce. The federal contracting process shall be streamlined to enhance speed and efficiency, reduce costs, and require federal contractors and subcontractors to comply with our civil rights laws accordingly. That's awesome. Executive Order 11246 of September 24th, 1965, Equal Employment Opportunity, is hereby revoked. For 90 days from the date of this order, federal contractors may continue to comply with the regulatory scheme in effect on January 20, 2025. The Office of Federal Contract Compliance Programs within the Department of Labor shall immediately cease promoting diversity. A. B. Holding federal contractors and subcontractors responsible for taking affirmative action. And C. Allowing or encouraging federal contractors and subcontractors to engage in workforce balancing based on race, color, sex, sexual preference, religion, or national origin, which is really great. In accordance with Executive Order 13279 of December 12, 2002 Equal Protection of the Laws for Faith-Based and Community Organizations. The employment, procurement, and contracting practices of federal contractors and subcontractors shall not consider race, color, sex, sexual preference, religion, or national origin in ways that violate the nation's civil rights laws. Those are really important. We're really kind of, making a point to acknowledge the civil rights of Americans, and that's the American way. The head of each agency shall include in every contract or grant award a term requiring the contractual counterparty to grant recipient to agree that its compliance in all respects with all applicable federal anti-discrimination laws is material to the government's payment decisions for the purposes of Section 3729 B4 of Title 31 United States Code. And B, a term requiring such counterparty or recipient to certify that it does not operate any programs promoting DEI that violate any applicable federal anti-discrimination laws. See, they're not really saying that diversity and equity and inclusion, the terms themselves are bad. They're just saying, you can't do it in a way that's discriminatory, which is kind of the point. The Director of the Office of Management and Budget, OMB, with the assistance of the Attorney General as requested, shall review and revise as appropriate all government-wide processes, directives, and guidance. Excise references to DEI and DEIA principles under whatever name they may appear from federal acquisition, contracting, grants, and financial assistance procedures to streamline those procedures, improve speed and efficiency, lower costs, and comply with all civil rights laws, and terminate all diversity, quote, equity, quote, equitable decision-making, quote, equitable deployment of financial and technical assistance, quote, advancing equity, quote unquote, and like mandates, requirements, programs, or activities as appropriate. Section 4. Encouraging the private sector to end illegal DEI discrimination and preferences. A. The heads of all agencies, with the assistance of the Attorney General, shall take the appropriate action with respect to the operations of their agencies to advance in the private sector the policy of individual initiative, excellence, and hard work identified in Section 2 of this order. To further inform and advise me that my administration may formulate appropriate and effective civil rights policy, the Attorney General, within 120 days of this order, in consultation with the heads of relevant agencies and in coordination with the Director of OMB, shall submit a report to the Assistant to the President for Domestic Policy containing recommendations for enforcing federal civil rights laws and taking other appropriate measures to encourage the private sector to end illegal discrimination and preferences, including DEI. The report shall contain a proposed strategic enforcement plan identifying key sectors of concern within each agency's jurisdiction, the most egregious and discriminatory DEI practitioners in each sector of concern, and 3, a plan of specific steps or measures to enter DEI programs or principles, whether specifically denominated DEI, quote-unquote, or otherwise, that constitute illegal discrimination or preferences. As part of this plan, each agency shall identify up to 9 potential civil compliance investigations of publicly traded corporations, large nonprofit corporations and associations, foundations with assets of $500 million or more, state and local bar and medical associations, and institutions of higher education with endowments over $1 billion. Other strategies to encourage the private sector to end DEI discrimination and preferences and comply with all federal civil rights laws. Litigation that would be potentially appropriate for federal lawsuits, intervention, or statements of interest, and potential regulatory action and sub-regulatory guidance. Section 5. Other actions. Within 120 days of this order, the Attorney General and the Secretary of Education shall jointly issue guidance to all state and local educational agencies that receive federal funds, as well as all institutions of higher education that receive federal grants or participate in the Federal Student Loan Assistance Program under Title IV of the Higher Education Act 20 U.S.C. 1070, regarding the measures and practices required to comply with students for fair admissions. President and Fellows of Harvard College, 600 U.S. 181 of 2023. Section 6. Severability. If any provision of this order or the application of any provision to any person or circumstance is held to be invalid, the remainder of this order and the application of its provisions to any other persons or circumstances shall not be affected thereby. Where's my glasses? Section 7. Scope. This order does not apply to lawful federal or private sector. This order does not apply to lawful federal or private sector employment and contracting preferences for veterans of the U.S. Armed Forces or persons protected by the Randolph-Shepard Act, 20 U.S.C. 107. This order does not prevent state or local governments, federal contractors, or federally funded state and local educational agencies or institutions of higher education from engaging in First Amendment protected speech, which I would say would include whistleblowers' protections. This order does not prohibit persons teaching at a federally funded institution of higher education as part of a larger course of academic instructions for advocating for, endorsing, or promoting the unlawful employment or contracting practices prohibited by this order. Section 8. The general provisions, nothing in this order shall be construed to impair the otherwise affect the authority granted by law to an executive department, agency, or the head thereof, or the functions of the Director of the Office of Management and Budget relating to budgetary, administrative, or legislative proposals. This order shall be implemented consistent with applicable law and subject to the availability of appropriations. This order is not intended to and does not create any right or benefit substantive or procedural enforceable at law or in equity by any part against the United States, its departments, agencies or entities, its officers, employees or agents, or any other person. Signed, the White House, January 21st, 2025.